This program contains content that may disturb some viewers.
The Royal Commission into Institutional Responses to Child Sexual Abuse was supposed to be a turning point for survivors. For 5 years, it heard a terrible history of abuse in orphanages and scout halls, presbyteries and playgrounds. Organisations apologised.
I swear by Almighty God.
I swear by Almighty God.
There was a kind of criminal negligence.
It was a colossal fail of culture that led to the colossal failure of leadership.
Scouts Australia has a responsibility to survivors of abuse, and we will honour that.
I remember watching those videos. Maybe sometimes I wish that I didn't, and it just makes me so angry.
Has everything changed?
Sure has, it's got worse.
As lawyers have taken to the courts to fight for compensation, some institutions have found different ways to deny victims justice.
This decision today by the Supreme Court flies in the face of everything that the Royal Commission into Child Abuse stood for.
Organisations are in a ferocious battle to block claims from even getting to court.
Why has your client sought to have a permanent stay?
They lost my respect, and I don't understand why they won't just stand up and be accountable for what they've done.
It's disgraceful, really, because what they're in effect doing, they're hiding behind tombstones and throwing rocks at the victims.
5 years on from the historic Child Abuse Royal Commission, are survivors any closer to receiving justice? As notorious perpetrators begin to die off, a fierce new battleground is emerging. We go behind the scenes of the legal fight as institutions employ extraordinary tactics designed to shut down victims' rights to seek proper compensation. On Sydney's northern beaches, barrister James Mercer's day starts before dawn.
I'm personally moved by the plight of survivors and have seen firsthand the devastating effect not only child abuse has, but the deployment of legal barriers has on survivors.
Mr Mercer is one of few barristers who do only institutional abuse cases. One of James Mercer's clients is former Marist Brothers student Ted Kawicki. At a school in Maitland in country New South Wales that was notorious in the 60s and 70s, Ted Kawicki alleges abuse by a long-dead brother of the Catholic order.
That place was a pedophile's paradise. They acted with impunity, they did exactly what they wanted.
He's now on his way to meet up with James Mercer and instructing solicitor Michelle Martin to discuss legal tactics in his case against the Marist order.
And Ted, I'd like to introduce you to James Mercer. He's the barrister.
How are you, James?
Good to meet you.
Yeah, and come and take a seat there, Ted.
Okay.
The Marist brothers have threatened Ted with what's known as a permanent stay. an attempt to stop his case from proceeding in court.
The weapon of last resort. They've dragged this permanent stay out of the gutter and brought it out there now. So it's a one-size-fits-all. That means convicted criminal thugs are simply let off the hook once they die.
These lawyers have had to deliver difficult news to their client and manage his expectations.
It seems likely that the stay will be granted on the current law, but really your options are either capitulating and discontinuing your claim.
Which is not an option.
Or fighting it.
Oh, there's no way in the world will I ever give up. Never.
Right.
Never in a million years. His death, he rests in peace, and he leaves the misery behind.
And the door's closed.
And they hide behind tombstones, you know? Dead priests, dead brothers. It's disgraceful.
The Royal Commission was supposed to fix this situation, inspiring law reform that removed barriers, including the statute of limitations, which had prevented survivors from suing if too much time had passed. But increasingly, survivors are now facing a new obstacle, the permanent stay. It's sometimes referred to by lawyers as the dead man's defence.
They come forward now and they're being told, well, it's too late. You suffered all those years, you didn't come forward before, and now your perpetrator has died, so go away. That's the message that they get, and it's devastating.
More and more institutions are fending off claims in sexual abuse cases by applying for permanent stays. A permanent stay essentially puts a stop to a case where it's considered so oppressively unfair to a party that it would be an abuse of process. A permanent stay is supposed to be used only in exceptional circumstances. How often are threats of permanent stays flying into the inboxes of solicitors?
From particular organisations where there is a dead abuser, alleged abuser, or an infirm alleged abuser, they are almost in every case where those facts exist, being threatened.
Like it or not, and it doesn't matter about what you think about the merits or ethics or morals of the defendant, everybody in Australia, plaintiffs and defendants, they've got a right to a fair trial under our judicial system, and this is a reflection of that governing theory. And it doesn't matter whether you're a good guy or a bad guy, you're entitled to invoke it.
Barrister Geoffrey Watson has acted for both sides in these cases.
Typically, the worst problem is the absence of witnesses, live bodies. People have died, people have become infirm, and they're unable to respond to it. Quite often you will find that the records kept by the institutions about the attendance of particular individual claimants are themselves scanty, and you'd be surprised how often it pops up that there are no school records of a person being in a particular class in a particular year or being taught by a particular person.
One of the dead men's graves belongs to Father David Perrott.
Father Perrott hurt so many children, you know, and Indigenous children, families that were vulnerable.
On a chilly May night in 1973, at an imposing building in Armidale in country New South Wales, a car pulled up and deposited a 4-year-old Aboriginal girl and her siblings.
It was very terrifying and probably like something out of a horror movie, I would say.
St Patrick's Orphanage was run by the Sisters of Mercy, and from time to time it would be home to Mimi, her 2 sisters and her brother.
It was very petrifying, actually. You know, to be removed from our family and our community in the night time. I recall those massive big, I would say like a European style staircase, and just remember walking up and down those stairs. I just felt very small in that space, you know.
During her stay there, what seemed to be a friendly face often appeared on the scene. His name was Father David Perrett. All the kids called him Father Dave. He had a predilection for Aboriginal children.
When Father Perrett came to the orphanage, I can remember thinking as a child, why do all the Indigenous kids run up to him? So he had a particular way with Indigenous children. He paid a lot of attention to us.
Father Dave began to abuse Mimi in her dormitory and an attic room.
I remember being in the attic upstairs and the feeling that I wasn't meant to be there. It seems like trauma is not a strong enough word for what it felt like. I don't know, but the feeling still stays. It's still in my body.
So you were only 5
when
he raped you?
Yeah.
And he did it on multiple occasions?
Yeah. I can recall a massive change coming over me. My whole being and my whole sense of safety in the world disappeared, and I had no trust in anyone really, and I just went so much inside of myself, and I actually stopped talking.
I'm acting for a number of people whose lives have been ruined by what Father Dave Perrett has done to them. It ranges from all sorts of areas. It's not just in Armidale. He unfortunately continued abusing children across New South Wales.
5 years ago, Mimi was contacted by Armidale Police, who had spoken to other Perrett victims from Aboriginal communities.
I want their lives to mean something, you know, to hold him and them accountable. It's not okay that he hurt so many of, you know, us kids.
Vulnerable kids?
Yeah.
He was criminally convicted in 1996 for abuse in relation to Aboriginal children in Walgett. He was consequently charged again with, I believe, 140 different offences against 40 different children, mainly men, but there was also 3 girls.
And Mimi was one of those girls?
Yes.
The 40 complainants were devastated when Father David Perrett died 6 months before the trial was due to start. With lawyer Alessandra Petit, Mimi commenced legal proceedings against the Diocese of Armidale.
The Diocese of Armidale need to take responsibility. Regardless of the fact if he's dead or not, they need to acknowledge the harm that he's done, the ongoing harm, that the trauma that, you know, his victims are still suffering.
But despite all the evidence of Perrett's offending at this place and elsewhere, the Diocese of Armidale sought a permanent stay.
I was genuinely gobsmacked because Father David Perrett had been charged with the abuse. He has a record of abusing other children, and I really didn't think that a wealthy institution would file a stay application on a First Nations woman's case for being sexually abused as a child while she was in their care.
I'm scared because I know how much power and wealth they hold, and I'm also frightened because the legal system seems to be aligned with that power, yeah. And I'm expecting that nothing's going to come out of it, that this is going to be 8 years of my life of being re-triggered and re-traumatised. just to be, bitterly let down. But I guess the reason why I'm talking to you today is for other victims, because I'm not the only one from that orphanage that is, trying to bring that diocesan to justice.
In the case of another Indigenous woman who alleges historical abuse when she was a state ward in Queensland, a permanent stay was 2 weeks ago granted by the state's Supreme Court. This was the first time that a state government, rather than a private or religious institution, was prepared to use these legal tactics in a sexual abuse case since the Royal Commission.
There are some cases where a stay is appropriate, even though there was a high probability that the abuse occurred. And that's because normally you're not suing the perpetrator. You're suing somebody else and saying you are responsible for the acts of the perpetrator, which might mean that the ultimate defendant is not capable of getting a fair trial. And that's despite the fact that the perpetrator may be guilty as sin.
Is there a cognizance in your experience on behalf of institutions of how devastating this is on the other side of the ledger?
Oh, I mean, I'll just tell you at a personal level. You bet there is. They're not inhuman bastards, I can assure you.
The question many will be asking is, why don't survivors apply under the National Redress Scheme that was set up after the Royal Commission? Why bother suing anyway? The answer is money. The maximum amount that victims can claim under redress is $150,000. The average amount granted is $88,000. And if you apply for redress, you give up your right to sue. Melbourne plaintiff lawyer Judy Corton acts for many victims of some of Victoria's most infamous pedophile clergy. Some of these offenders have cost their institutions millions of dollars in settlements to Dr. Corton's clients alone.
What do you think is the primary motivation for these institutions seeking permanent stays?
Money. You can't get any more basic than money. They're having to pay out big dollars now in many claims, and they're getting scared, basically. They're getting scared.
These institutions will often say, particularly when you've got prolific offenders, you're just going to bleed us dry.
My response to that is, let's bleed them dry. They should be bled dry, I'm sorry. They should be bled dry. How much harm over how many decades have the institutions caused? Not just the little child, their families. How many suicides and the impacts on families? I'm sorry, they should be bled dry.
In a seedy part of Melbourne's St Kilda, we meet 54-year-old James. He's living in a rundown bedsit. He doesn't want his face to be seen because he doesn't want his family to be ashamed of him.
I don't deny that I'm an alcoholic. I've had to use alcohol my whole life so I could survive. If not, I would have been dead years ago. It's just a survival technique.
When did you start drinking every day?
About 3 o'clock.
James's life started out in a place of privilege where his future was supposed to be golden.
And that's you there?
That's me.
And that's your mum?
That's Mum.
She's pretty glamorous.
Yeah.
James came from a very wealthy part of Melbourne.
We grew up in the Toorak South Yarra area. My early life was very good. We had a live-in nanny.
James was sent to perhaps the most prestigious Anglican school in the country, Geelong Grammar. From his first year, the little boy's life set on a terrible course. He later defaced his class photo
depicting himself as the devil. James's legal documents allege horrendous abuse by 4 primary school teachers at Geelong's Toorak campus.
What was done to James is really one of the most appalling and devastating cases of abuse that I've come across.
James never told his parents. Discussing it causes him extreme distress.
These fucking assholes are fucking monsters, and they fucking
You're doing fine, James.
They destroyed my fucking whole fucking life.
In July last year, Geelong Grammar's lawyers told solicitor Kim Price they accepted James was abused and they would admit liability. But when a compensation figure was calculated in the millions, James and his lawyer were shocked at what happened next.
Well, they took a look at it and they said, we revoke our admission in relation to the allegations and we revoke our admission of liability. And on top of all of that, we're now going to seek to shut down this entire case.
With a permanent stay?
That's right.
So let me get this straight. Geelong Grammar admitted liability, but when they saw how much it was going to cost them, they revoked that liability.
Well, that was the sequence of events. Yep.
Geelong Grammar delivered this news to James in the days before Christmas.
I was sitting there and I was like, fuck, what? It's like, how can this happen? The case is meant to be over.
I told them that I was outraged and appalled. In my view, the admission of liability was always disingenuous and really just conditional upon James approaching his claim in a manner that suited them.
Which was in a way that they would save money.
Absolutely.
Good to see you. All good?
You too, mate.
Yep.
With the permanent stay hearing looming, Kim Price meets up with James, who'll have to make a tough decision.
Given the state of the law, we really face some serious risks of the case being shut down. So it's time to make a decision really about what you want to do.
So they're making us roll the dice and... Okay.
Like, as your lawyer, I would hate to see you walk away with nothing out of this.
No, yeah,
I also don't want to settle the case.
No.
But
God.
Ultimately, you've got to do what's in your best interest.
I know. Oh. If we fight, what happens if I lose?
You'll get nothing.
Right.
James decides to settle.
Where do I sign that? There?
Yeah.
Thanks, mate. I didn't want it to end like this. I wanted my day in court. Thanks, mate.
By raising the prospect of the permanent stay, Geelong Grammar saved $4 million from the amount James's lawyers assessed he needed, because his life had been so comprehensively destroyed. But it did agree to pay him more than $2 million. The school declined to discuss James's case, but in a statement made a general apology to victims for harms suffered. Permanent stays aren't the only tactic deployed against victims. In a small country town outside of Canberra, we meet survivor Josh Burns and his auntie Joanne.
It's good to be able to talk about it, talk about my story, talk about our story.
They have an astonishing story of what an institution did in order to limit its liability.
It felt like they wanted to protect their own skin, like their own reputation. But definitely, to me, the protection of children seemed extremely low on their list of priorities.
The Burns were extremely committed Catholics. The family was delighted when Joanne's cousin, Dennis Burns, was ordained a priest. So when, each school holidays, young Josh and his brothers would go to stay with Auntie Joanne, Father Burns was more than welcome.
He was a priest. He's even more trusted and even more revered. So there was no question that he was an adult looking after these precious little children.
But when Josh was 12, in 1999, Father Burns began to betray the family's trust. Josh says the priest would go on to abuse him over an 8-year period.
I got a lot of emotions that come up when I start thinking about that. When I think about what it could take a man to take a child that was that innocent and to do the things that he did to me, knowing very well that he had all the power, that there was no authority, that I had to say no. I didn't even know that what we were doing was wrong.
In 2016, Josh Burns went to police. Father Dennis Burns was convicted.
There was no doubt whatsoever that he did what he did to you.
No, there was no doubt whatsoever. He pleaded guilty. I watched him stand in a courtroom and say, yes, I did these things.
Files were found in the Lismore archives revealing the diocese had known the priest was a danger to children 15 years before he ever abused Josh.
The files made notice and made comment that he offended back in 1984 against another little boy under very similar circumstances.
That little boy came forward as an adult to complain of the abuse to the church in 2006, while Father Dennis Burns was still abusing Josh. When Josh Burns used this prior knowledge as the basis of a civil claim against the diocese, he and his auntie were gobsmacked at the response.
So all of a sudden I get a phone call one afternoon from Joshua's lawyers, and Joshua's on the phone saying there's a cross-claim coming against me, that it was my negligence because I should have reasonably foreseen that a priest would have abused a child, and that I was negligent for leaving this priest with unsupervised time with a child, and that I could be up for compensation, interest, all the costs, and anything else the court deems. It didn't sit with me that I would have known that. And then when I found out later that they actually did know that, I thought, oh, reasonably foreseeable are the words that apply to them, not me.
How would you characterise what they did?
Oh, evil is the first word that comes to me.
The evidence clearly showed that they were aware of what he was like, that he was a predator. For them to turn around and suggest to my auntie it should have been foreseeable to her that this might happen seems extremely hypocritical. It just seemed like they were just not interested in people. They're just not interested in us, in who we were or what we'd been through.
What do you think they were interested in?
Just protecting themselves.
Ultimately, the Diocese of Lismore agreed its cross-claim against Joanne should be dismissed. It settled with Josh. It declined to speak to Four Corners.
They lost my respect. And I don't understand why they won't just stand up and be accountable for what they've done. I don't understand why they can't just go, I'm sorry, we messed up.
As they battle their way through these complex cases, plaintiff lawyers say some institutions are more robust litigants than others. The Marist brothers were raised by most lawyers Four Corners spoke to. The Royal Commission found, historically, a staggering 1 Marist brother in 5 was an alleged perpetrator.
You are an old boy of a Marist school. How would you describe the approach of the Marist brothers when it comes to permanent stays?
I personally am quite confronted with some of the tactics that I have seen deployed in relation to some cases. I've encountered examples where the threat of a stay has been made simply upon giving notice of an intention to bring a claim against a well-known abuser.
At their core, they talk about kindness and moral values, but then this is how people are getting treated, and we really want to raise this issue because there are many people who are part of these institutions. They send their children to the school, and then do they know that this is what's happening when it gets to this, when a claimant comes forward, and it's contrary to the assurances that they've given publicly, and we think that it's something that people need to know about.
Marist Brothers Australia declined to be interviewed for this program. In a statement, it says, stays are an accepted part of our legal system, are available to all parties and have been exercised by many organisations. It says the Marist brothers only apply for permanent stays when it seems a fair trial is not possible. One man who has been dealing with the Marists for a long time is Ted Kawicki. The Marists say they've been trying to mediate with him in good faith. They've just made him a low offer, which Ted will not accept. So he's taking his fight to Canberra.
I was a little boy then, little innocent little boy, but I don't want to play the victim here. I want to go in there and expose these bastards, you know? Hang on, David. Ted Kawicki, right here.
Yeah, I know a lot about you.
Ted sees the only hope for survivors like him threatened with permanent stays is a change in the law.
Parliament must remove this obscenity off the statute books because that denies hundreds and hundreds of innocent victims their right to due process, whilst affording known pedophile criminals sanctuary in the grave.
Green Senator David Shoebridge has already written to the New South Wales and Commonwealth Attorneys General and agrees to raise it in the next Senate estimates hearing.
Obviously, when the law is misfiring, when the common law in this case is misfiring, and it's not providing just outcomes, that's when you need parliaments to step up. That's what parliaments were asked to do by the Royal Commission. And it's exactly the same now. This is history repeating.
I very much doubt that a legislature would be minded to allow cases to go to trial if they were unfair trials, in the sense that it was wrong or bad or the evidence was insufficient to permit a fair trial being had. That would be strange legislation to allow that to occur. The use of this kind of procedure for a stay of proceedings is perfectly consistent with what the Royal Commission had to say.
But Barrister James Mercer says permanent stays were little more than a footnote in the Royal Commission's final report.
Before that, they were used in exceptionally rare circumstances, and particularly in civil litigation.
And how often are they being used now?
In the historical abuse space, it seems that they are being used insofar as that the reported decisions are coming through almost on a weekly basis. It really is a situation which is grave, and the effects of it are untold in terms of the personal toll on survivors.
It makes me question why taxpayers spent $370 million on a Royal Commission when we are almost what seems to be in pre-Royal Commission days. I find it offensive on a moral basis that a technical legal argument is able to take precedent over what should happen. We want to have a trial. We're not saying we've won yet, but you've got to give someone the opportunity to have a trial, because that is part of the healing, and that is part of having the ability to stand up for the little girl or the little boy that they're there for.
Politicians are waiting until the High Court of Australia has spoken. A crucial case will be heard next week.
The High Court judgment survivors and their lawyers are anxiously waiting for concerns a complaint of abuse by a woman known only as GLJ. GLJ alleges that when she was 14, she was sexually assaulted by a father, Clarence David Anderson, a Catholic priest from Lismore in northern New South Wales, who was known to have abused children, but only boys. The Diocese of Lismore is arguing for a permanent stay on the basis that it can't possibly get a fair trial because Anderson died in 1996, long before GLJ ever came forward.
GLJ, in many respects, has frozen in time the hopes of most survivors whose cases either face or may face a stay as to whether or not there is any viability in them bringing a case into the future.
One survivor who is nervously anticipating the High Court's decision in GLJ is Matt Barker.
I have been very anxiously watching it. You know, the result of that court case literally changed the course of my world, you know.
It's no exaggeration to say Matt's own case has sent shockwaves through the legal community. The institution he's suing has no tombstone to hide behind.
The perpetrator's still alive.
And in jail?
Yeah, and in jail.
So they could speak to him about this?
Yeah, they could speak to him, yes.
And he's already pleaded guilty to this?
Yes, he's pleaded guilty, yes.
Matt was first abused at 11 years old. He was a scout. His abuser was a scout master in Sydney's West. Offering to help Matt work towards his scout badges, the man brought the boy to a lonely caravan.
When we first arrived back at the caravan, and pretty soon it just moved on to where he, started abusing me. I was in shock. You know, I was completely shocked about what was going on. I didn't really understand what was happening. And, you know, I still have a very clear feeling of right at that moment of the first abuse beginning of just something breaking inside.
In June 2020, the man pleaded guilty to abusing 4 scouts, including 24 charges in relation to Matt.
So there was absolutely no doubt that your perpetrator actually did this to you and to the other boys?
No doubt whatsoever.
Scouts New South Wales went to the Supreme Court and they sought a permanent stay.
It definitely makes me very angry when I think about their behaviour. I really don't think that Scouts have lived up to the commitments they made to the Royal Commission.
How does it feel from a survivor's point of view when you are trying to, as you say, take back agency and the institution just pulls down the shutters?
It's incredibly frustrating, and it just feels like that any of the words and apologies that Scouts have made about doing better in this area are empty.
It doesn't go Matt's way. Supreme Court Justice Peter Garling awards a permanent stay to Scouts because too much time has passed and some Scouts' decision makers are dead. Justice Garling says Matt's convicted perpetrator, who offered to give evidence from jail, is self-serving. Justice Garling awards costs against Matt to Scouts. To contextualise, Scouts New South Wales' net assets are worth $187 million.
This decision today by the Supreme Court flies in the face of everything that the Royal Commission into Child Abuse stood for. My client is devastated. My client is calling upon the Attorneys General to look into this law again and rectify it to go back to what the Royal Commission wanted it to be. Victim-orientated, survivor-orientated, to support them, not the institutions, once again allowing the abusers to slip through the fingers of justice.
Despite Four Corners' repeated conversations with their corporate communications representative, Scouts New South Wales declined requests for an interview. But we approached Scouts lawyer Patrick Thompson outside court.
I just wanted to ask you, will you be enforcing costs against this victim of a convicted pedophile? Will Scouts be doing that?
Asking that question, but I can't make any comment on that.
Scouts is an organisation which is responsible for the care and safety of children. Why has your client sought to have a permanent stay against a victim of a convicted pedophile who's in jail and is alive and is competent and is in his 60s? Can you explain why that's the case?
In a statement, Scouts New South Wales acknowledged Matt was the victim of an inexcusable and abhorrent crime and said it had apologised to him. Matt was gutted when he got the news of the judgment.
I was trying to sleep at night when you're shaking, trembling with anger about this decision. You know, you're trying to get through each day just on the verge of tears.
Keeping him awake at night now is that the judge ordered him to pay Scouts' costs. Scouts aren't challenging the judge's decision to award them those costs.
Meeting those costs would literally mean I lose my house and face bankruptcy. So, yeah, I don't know what to do next. This decision, it doesn't just affect me, it affects all the other victims in my case. It affects so many other people that have got claims live against organisations like Scouts. So this decision really needs to be appealed. You know, I don't know how I'm going to gather the financial resources to do that. I don't know how I'm going to gather the emotional and psychological resources to do that. But I just have to.
What would you say to the politicians who are watching this story?
This judgment is a perfect example of why the law needs to be changed. The Scouts, you know, they said to the Royal Commission that they were going to treat victims of sexual abuse with consideration and mindfulness that litigation can be traumatising. They said they were going to consider meeting legitimate claims without litigation. They're not doing that. That's not what they're doing here. Instead, they're re-victimising me. They're treating me with unspeakable cruelty, and it hurts. So what the legislators need to do is change the laws so organisations can't behave like that.
If this program has raised concerns for you, you can contact one of these services.